Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2, Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here today. This morning, we have our arraignment docket. And what the arraignment docket is, it's an opportunity for the court to inform you as to what you've been charged with, what your rights are, and what options you have concerning your case. The case that you have in this court is classified as a misdemeanor case. It is not a felony case. The difference between the two, the felony and the misdemeanor, is with felony cases, the range of punishment can require that you be sentenced to the state penitentiary or the Texas Department of Criminal Justice. For misdemeanor cases, you cannot be sentenced to the state penitentiary. However, your sentence could include punishment in the county jail or confinement in the county jail. Misdemeanors are divided into Class A, Class B, and Class C misdemeanors. The highest misdemeanor that we have is a Class A misdemeanor. The next one below that is a Class B, and the lowest one is a Class C misdemeanor. We do not handle Class C misdemeanors in this court. The courts that handles Class C misdemeanors are the traffic court, like the municipal court, or the justice of the peace court. Like, for example, if you get a speeding ticket, that's normally a Class C misdemeanor. However, we do handle Class C appeals, which means if the case is appealed from justice court or from municipal court, we do handle those cases. But the cases that we normally handle are Class A and Class B misdemeanors. If you have a Class A misdemeanor, the range of punishment is confinement in the county jail for a term not to exceed 1 year, which is 365 days, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, when I say that it cannot exceed, that means that it cannot go over that amount. It can go below that amount, but it cannot go over that amount. If you have a Class B misdemeanor, the range of punishment is confinement in the county jail for a term not to exceed 180 days, which is 6 months, or a fine not to exceed $2,000, or both such fine and confinement, which means you can get jail time and a fine. You may be eligible for probation. There are 2 types of probation. One type is called adjudicated probation, and the other type of probation is called unadjudicated probation. The difference between the two is as follows. With adjudicated probation, it does result in a conviction on your record as soon as you get on it. Unadjudicated probation, it does not result in a conviction on your record. Now, with the adjudicated probation, which does result in a conviction on your record, there is something that is called judicial clemency. What that means is that the judge can set aside your conviction. And the way it works is you have to successfully complete the probation. The probation has to expire, which means you cannot have any more time left on the probation. And you have to be successfully discharged, meaning let off of the probation. If those things happen, then any complaint, affidavit, or information that has been filed against you can be dismissed. And if that happens, you will not have a conviction on your record. Now, if you get a subsequent conviction, a conviction later on, then this case that you got judicial clemency on can be resurrected, revived, or brought back up and used against you. And if you try to get a license with CPS, then they can deny giving you a license, or if you have a license, they can revoke or suspend the license. Now, what I did not say is that once you complete the probation, once you discharge the probation, and once the term of probation ends, then the court can allow you to come back in the court to withdraw or to take back your plea. Okay. Now, with deferred or unadjudicated probation, we commonly refer to it as deferred probation. It does not result in a conviction on your record. However, so if it does not result in a conviction on your record, you may qualify for what is called a non-disclosure. Non-disclosure means we cannot disclose the fact to the general public that you were on deferred adjudication for your case. Now, if you violate the terms and conditions of your deferred probation, your case will not get dismissed. It may not get dismissed, because what will happen is you'll have a hearing to determine whether or not you violated your probation. And if the court finds that you violated your probation, then the court can, it may result in a conviction on your record. And if it does result in a conviction on your record, then your case will not get dismissed and you cannot qualify for a non-disclosure. Okay? If you are not a U.S. citizen on a plea of guilty or no contest, it may result in deportation, which means that you could get kicked out of the country, or it may result in exclusion from admission, which means that if you're outside the country trying to come in, you could be prevented, they could prevent you from coming into this country, or it may result in denial of naturalization, which means if you file an application to become a citizen, they can deny your application of citizenship. As a defendant in a criminal case, you have three options. And you were handed out some paperwork, and in that paperwork, it has the options that you have concerning your case. Number one, hold on a minute, let me do this here. Now, the paperwork that was handed out to you earlier is titled Judge's Explanation of Rights to Defendants Without an Attorney. And as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire an attorney, you may need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of this document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. Or if your choice is, I have hired an attorney whose name is, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. Or if your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. Or if your choice is, I have hired or I have a court-appointed attorney whose name is, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Or if your choice is, I want to waive my right to an attorney and represent myself, then you will place your initials on the fifth line to the left. Now, for those of you who will be applying for court-appointed counsel, you would have to fill out a financial questionnaire that we have here in the court. And we have someone, for those of you who need assistance, to assist you. For those of you who will be waiving your right to an attorney and representing yourself, before you can talk to the prosecutor about your case, then you would have to sign a written waiver of your right, and that is the second page on the clipboard that you have, and I will go over that. And it reads, waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Says, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 6th day of April of 2021 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you'll sign where it says defendant, and you'll put today's date, April 6th of 2021. Now, you also have a right to have a trial by jury. That area over there where you see those 12 chairs, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your jury, and they'll listen to the evidence in your case. After listening to all of the evidence in your case, they will decide whether or not you are guilty or innocent. You also have a right to waive or give up that right to have a trial by jury. That simply means that you have a right not to have a jury trial. And by doing so, you could just have a trial before the court. We call that a bench trial. That's a trial before the judge without a jury. Or if you and the state reach a plea bargain agreement, you could come before the court with that plea bargain agreement. Or if y'all have not reached a plea bargain agreement and you still would like to enter a plea of either guilty or no contest, you could come before the court on what we call an unagreed plea. Basically, you and the state have not come to an agreement and you would like the court to assess the punishment. You also have a right to have witnesses to come to court. And witnesses, they sit in that chair over there. We call that the witness stand. The witness, that is, they can either testify for you or against you. You can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive, which means to give up your right to have witnesses come to court. And by doing so, you will not be calling any witnesses on your own behalf. You also have a right against self-incrimination, which means you have a right not to testify in your case. Now, you can waive or give up that right against self-incrimination as well and decide to testify in that case. Now, you also have a right to have discovery. Discovery, I guess by definition, you have a right to discover or to see the evidence that the state has against you. If you want to see that evidence, the state will allow you to have access to that evidence. Or if you have an attorney, your attorney will have access to that evidence. Now, you also have a right to waive or give up your right to have discovery as well, which means you have a right to tell them, well, I don't want to see the evidence. You or your attorney, depending on whether or not you're representing yourself or you're being represented by an attorney, will have an opportunity to talk to the state to see if you can reach a settlement. We call it a plea bargain agreement, if you are able to reach an agreement on your case. If you are able to reach a plea bargain agreement, the court does not have to follow that agreement. The judge does not have to follow when I say the court. And if the court does not follow your agreement that you have reached with the state, then you can take back your plea of either guilty or no contest. You can say, well, judge, I'll take back my plea since you're not following out my agreement. That's your right. Now, if the judge does follow the plea bargain agreement, then if you decide within 30 days that you would like to appeal your case because you think that, well, the court committed an error by convicting me or I was wrongfully convicted, then you have to get the court's permission if you want to appeal. And if the court gives you permission to appeal, your case will go to the Ninth Court of Appeals. The Ninth Court of Appeals is right above us on the 3rd floor. They can either grant or deny your appeal. If they grant your appeal, then they can find you not guilty. You could be acquitted. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then at that point, you can appeal it to a higher court than them within 30 days. That higher court that you would have to appeal it to is called the Texas Court of Criminal Appeals, located in Austin, Texas. It is the highest criminal court in the state of Texas. You would have to file what is called a pro se petition for discretionary review. Pro se petition means you would have to do it on your own without the assistance of a lawyer. So you'll be representing yourself, filing your petition. You'll be asking them to see whether or not your appeal should have been granted, whether or not you was wrongfully convicted, or whether or not this court committed an error by convicting you. They can either grant or deny your pro se petition. If they grant your pro se petition, they can acquit you, which means find you not guilty, or they can send the case down to this court, order this court to give you a whole new trial. Or if they deny your pro se petition, then at that point, your conviction will stand. Every one of you have been arrested on your case. That's why you're here for arraignment. This is your first time since the arrest. And every day that you spent in jail before you bonded out, you can get credit for that towards your sentence. So for example, let's say you spent 5 days in jail and you and the state has reached a plea bargain agreement and it's 5 days. That simply means you won't have to serve any more time in jail because you'll be given credit for time served. You've already served the 5 days. Now, if it's more than that, for example, if they offer you 7 days, you serve 5, that means you have 2 days to serve. Now, every day that you spent in jail also counts as $100 per day toward your fine and court costs. So if the state is offering you a fine and court costs as your punishment of $500, you spend 5 days in jail, that means you don't have to pay $500. Why? Because you've already spent 5 days in jail. The time you spent in jail has already paid it off. So therefore, your fine and court costs will be what we call taxed and retired. You won't have to pay it. Now, if you have more than that, for example, if it's $700, that fine and court costs, and you've served 5 days, that means you would have to pay $200. Now, if you're unable to pay the fine on that day, then we could put you on what is called a payment plan, or if you cannot pay it at all, then we can convert the fine and court costs to community service. And for every hour of community service that you do, you get $12.50 toward your fine and court costs. So if you do 8 hours, that's $100 a day, basically is what it is. So your fine and court costs, if you're given that, it could be converted to community service if you cannot, if you do not have the money to pay the fine and the court costs. Now, Jefferson County has a program that is called pretrial diversion, and it's for first-time offenders. Those of you who do not have a criminal history and your case is not an unlawfully carrying a weapon or a resisting arrest. If you don't have those cases, your first time you may qualify for pretrial diversion. What happens in pretrial diversion is this. You get into the program, your case is dismissed, you complete the program, you can get it expunged from your record. What an expunction is, it means it can be wiped off, erased, or deleted from your criminal record. So for example, if it's expunged, somebody go look at your criminal record, it's not there. Okay. So, and also in order to get in the program, you have to have a lawyer to assist you with writing the application that the district attorneys need to see if you qualify to get into the program. The other thing is, if you are a veteran of any one of the branches of the United States military, any one of the branches, there's something that's called Veterans Court. Veterans Court is part of the pretrial diversion program as well. You can get into Veterans Court, complete it, case is dismissed, you get it expunged from your record. All right. The other thing is, this court has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program designed to address what we call recidivism. People committing crimes over and over. That's what recidivism means. And so it's designed to address the issue of people committing crimes over and over. And the way the program is designed is to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, raise our families, go to church. Now, with the program, we have partnerships with agencies in the community. And for example, the program deals with mental health, drug and alcohol abuse, and job training, job placement. And we have a partnership with Spindletop, MHMR, who has a program for mental health. We have mental health officers, counselors in the courtroom, and they can do what we call private interviews. Spindletop can do an assessment. They can do a treatment plan, either outpatient or inpatient, depending on what your needs are. Spindletop also has a program that is called ATAR, and this program is for individuals 21 years or younger, and it's a drug and alcohol treatment program. For anyone who is over the age of 21, then we have a relationship with OZAR, and that's the local mental health agency. They can do interviews, screenings, and develop a treatment plan, either outpatient or inpatient as well, depending on what your needs are. The other thing is we have a partnership with the Golden Triangle Empowerment Center. The Golden Triangle Empowerment Center has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for it stands for Center for Innovation, Commercialization, and Entrepreneurship. The CICE program is a job training and a job placement program in the hotel industry or the shipping industry or the chemical industry. Once you get trained in any one of those areas, they will assist you with getting a job in the area that you are trained in. If you do not have your high school diploma, CICE as well as Spindletop has a program for GED. So they can help you, assist you with getting your graduate equivalency diploma, the GED. All of these programs that I just spoke of have some benefits. One of the benefits is it's free. And it does not cost you anything. The other benefit is all of these programs that I just spoke of also can be used as community service. So for example, if you're given a fine and court cost, but you can't pay the fine and court cost, and your fine and court cost is converted to community service, if you're in one of those programs could be used as community service. So you can kill 3 birds with 1 stone. And the way it works is you got a fine and court cost, you can't pay it, it's converted to community service. And the community service is, if you're in one of these programs, it can be used as community service. So while you're sitting in class getting your GED, you're getting 1 hour, every hour you're getting 1 hour community service, and $12.50 is going toward your fine and court costs. Or if you're working while you're getting job training, the same thing. 1 hour is going toward your fine and court costs, okay, community service, and then if $12.50 is going toward fine and court costs. Or if you're in a mental health treatment, or if you're in a drug or alcohol treatment program, 1 hour of counseling, that's $12.50 toward your fine and court costs. And it is also being used as community service, 1 hour community service and $12.50 toward your fine and court costs. So all of these programs that I just spoke of are beneficial. The other benefit is with these programs, as I said earlier, these programs are free. Only thing you have to say is that I want to be in one of the programs, and then you'll be in one of those programs. Now, the other thing is, I tell people this all the time, when you come to County Court at Law Number 2 in Jefferson County, Texas, we don't have court as usual. We have unusual court. And the reason why I say that is because it's not because we're different, but it's because we're trying to make a difference of the lives of the individuals that come before the court, and we're trying to make a difference in Jefferson County. In County Court at Law Number 2, we do not just arrest the problem, we address the problem. And we believe that if we can address the problem, we can produce productive people. And if we produce productive people, for the most part, productive people do not commit crimes. And if people do not commit crimes, we make Jefferson County a safer place for all of us to live, work, go to school, raise our families, go to church, okay? And so that's what the CSI program is all about. Make Jefferson County a safer place for all to live. Now, we have some individuals here from Spindletop. We have Deputy Hinton, who's gonna come before you and tell you something about the program that they have with Spindletop. Deputy Hinton.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. I'm here with my partner here, Miss Lisa. She's a qualified mental health professional with Spindletop. There's one reason why we're here today is because Judge Holmes cares about people. He wants this program to be available to y'all to help y'all. What we found was people who go in and out of the jail, who are in or out of the court, are having legal issues. Sometimes there's underlying mental health issues or substance use disorders. So like the judge said, if we can address those issues, then we can eliminate a lot of the legal issues that are going on. If that applies to you, we want to be here for you. We want to advocate for you. We want to remind you that everything that happens this morning is free. Mrs. Lisa will privately speak with y'all and kind of give you some direction, some guidance, some options, some resources and things like that that help you have the best quality of life you can have and then get you out of the legal system as well. If it doesn't apply to you, it may apply to a family member. We welcome you all to talk about that as well, and we can help your family member and get them the resources they need and get you some direction on that too. But it's going to take one thing. Take y'all saying that you're going to ask. You're going to have to ask for it. This is not anything that we're going to force on you. It is something we just want to provide for you. It's up to you whether you want to utilize it or take advantage of it. Does anybody have any questions? Okay, as the court proceeding continues, I'll be going around and talking to each and every one of you. If you want to have a private meeting, we have a back room up here. We can speak in private and talk with you about anything that you want to talk about. Thank you.
All right, thank you, Deputy
Thank you,
Henry.
Your Honor.
Thank you, Lisa. Now, at this time, what we're going to do is we have some folks from our court personnel. They're going to come around and take up the clipboards and the applications that you filled out. If you need any assistance, we have someone here that can provide the assistance for you. This is going to take some time because we need to put you into the different categories, okay? So just be patient with us. And if you have any questions, feel free to ask. So at this time, the court is going to be in recess